We are live.
Okay, there we go. Hi, this is Curt
And Brad Pinsky.
and we're here for another edition of Fire Law Roundup for November, what is it, the 18th?
18th today. Yep.
18th. Okay, November 18th of 2024. Brad, go ahead, take it away.
I'm ready. Okay. Well, first we got some easy ones.
Yep.
We're going to Louisiana where, you know, well, the facts are a firefighter stole a credit card by making a number of purchases between, over a 7-month period or so in 24. He stole about $14,000, is alleged, right? He's fired for that. Alleged to have stolen. He made 180 different purchases. But I have to tell you something, right, to the viewers, fine, half the fault is on the person who makes those, unauthorized purchases. But the other half of the fault is on you, When you don't review every single receipt, invoice, credit card statement, that's on you. So the fact that it happens in 1 month, hey, that's 100% on them. But the second month is on you. You have to look at these things. And if you don't, look, the people who know how to steal the best are usually your treasurers or the ones with purchasing power or that authority. They know exactly what happens because they'll have tried it once in the past, right? They make a purchase, let's say probably in December or January. I'm making this up, but right before you make a whole bunch of purchases, you make 1 or 2, see if you got away with it, and 3 or 4, see if you got away with it. Now we're going to make 5 or 6. Hey, I keep getting away with it. Now we're going to make 180 different ones. This is on you, the owner, the operator of the fire department, of any entity. When somebody steals from you, if you're not looking, they're going to keep stealing from you. And my saying, the last thing I'll say about this is, don't be shocked. The person who steals from you is always the person you trusted. Otherwise, if you treated them like you didn't trust them, which is a proper thing to do, they wouldn't have gotten away with it. So don't be surprised that this happens. I'm not yelling at anybody, but
Yeah, this is it's a little bit different than the typical ones we've seen. Like you said, it's usually the treasurer or the fire chief, usually. This is different. And this one was a firefighter who was terminated and then he stole. He apparently stole it afterwards, which I'm not sure how that would work. You would think
they left a credit card in his name, apparently.
I guess, and well, it said, again, I'm going based on the news reports. I didn't see any official press release from the state police or the local police, but they said that he was terminated and then he stole it. So I guess it could be. I mean, we would, consider not returning a credit card that you had. But as you suggest, and that's why I think there's a lot more in some of these cases. At some level, the department should have picked that up after the first month, when these unaccounted for expenses started coming in, 180 of them. And it's pretty simple. Every credit card I've ever seen has a phone number on the back of it. They don't hide that number, and you're able to cancel the account. Every statement that comes in has that number. You call up and cancel the card, and that should put a kibosh at least on further stealing. So.
Yeah. But why you left somebody with that credit card, assuming that's what happened. Again,
yeah, it's not clear. It's not clear whether he, he got into the department somehow, got into the building and stole it, or whether or not he just failed to return it. Either of which is larceny. Whether you were supposed to return it and you didn't, that can be larceny. People don't think about it as larceny, but it is. So it's a form of larceny. So.
Yeah. Okay. So off that, let's go to Illinois, where we have a court who's dismissed a firefighter's civil rights claim. And here's what happened. So go back 10.
But Brad, I think you and I have talked about this case. I think, if not, I've got at least 3, 4, 5 entries in my database over this particular incident. So, but go ahead.
Yeah, I mean, the facts are pretty straightforward, right? The facts are about 10 or so years ago, there was apparently, let's call it a verbal altercation or comments made by an arson investigator to the plaintiff, and that they were apparently racially charged comments. So that is relevant here because the plaintiff, the person suing, claimed that the arson investigator had a bias against him based on race. Fast forward, there's a a club that the firefighter owns, a private business. There's a fire at it. The arson investigator was determined to have a good faith belief that probable cause existed to arrest the owner slash firefighter, and an arrest is made. The charges are ultimately, criminal charges are ultimately dismissed. And but now there was a lawsuit where the plaintiff and slash business owner slash firefighter claims that the arson investigator only pursued these charges as because he's racist or doesn't like me, etc. And the judge basically comes out and says, look, there was probable cause to make the arrest. And what he didn't say, though, is what normally we would see in harassment cases is a too remote in time argument, right? So in discrimination and harassment cases, if this was one of those, it is that, but forget the arson, right? So you fired me over something, change the facts. In those cases, where a plaintiff comes out and says, yeah, 2 years ago, the reason he's doing something to me now is because 2 years ago, he made these comments or whatever. And the courts normally say 2 years is too remote in time to sustain that. Here, yes, it's a discrimination claim, civil rights claim, but this is 10 years remote.
Yeah, but still, this is a criminal charge. And when you get into the facts, and I didn't get into all the facts of the fire, and I think that's pretty interesting. And you start to put things on the scales of justice. There's an awful lot of things that make it look like this guy had motive to set the fire. And in addition to that, he was at the scene when the fire broke out. He claims that he saw a figure go over to the building, that he was staking it out because of some past criminal activity. He was staking it out. He went over to the building and confronted the person who had some sort of a lighter and was trying to light the building on fire. And he got assaulted. And then the police came and, they tried to help him find the person. But in the meantime, the arson investigator comes, and somehow there's a question about evidence that was in the building somehow got outside the building. And whether or not it was firefighters that brought it out as part of normal firefighting, there's things that we bring outside the building, whether or not it was the local investigators that brought things out. The bottom line is that those items that he brought out had his DNA on it, and they use that DNA on the outside of the building, which I don't understand because he was outside the building. So of course his DNA would be outside the building. Again, a lot of factual questions here, but his allegation is that there was a attempt on this investigator's part to bring things out of the building, to plant evidence outside to make him look like he was the one who set the fire. So again, a lot of evidence that suggests that he had motive to burn. There's no proof that he set the fire. In fact, he has a plausible explanation for why he was there and how things happened the way they happened. He ends up getting charged. It actually went to a bench trial, and he was found not guilty. He was found not guilty at a bench trial. So, again, that doesn't necessarily mean he didn't do it. It just meant they didn't have proof beyond a reasonable doubt. He filed the first suit against that host fire department, called the host fire. It was the village of Sauk, I think it is. I don't know if that's how you pronounce it, but it wasn't his fire department. He was a lieutenant with the Country Club Hills Fire Department. Bottom line is, he files a suit against the department and the investigator, and then that gets dismissed. That case gets dismissed, and now he brings a second suit alleging a civil rights violation. And undoubtedly, there's that implication of wrongful prosecution, abusive process, etc. So the court said there's no proof that there's no documentation, any witness that testimony that the investigator brought the evidence out and planted it. So, and as much as he believes he was, set up, there's no proof of it.
Yeah,
so.
and yeah, that's so hard to do 10 years before and all that. I just,
Well,
my
I
only
think all that
comment.
was, I think it's all that is motive, because the question would be, the question in a normal case, and it's a legitimate question, is why would an investigator do this? Okay. Right. Well, here's the explanation. At least a plausible explanation for why he would. Like, why
And
would somebody, especially to another firefighter, why would you do that? Oh, you have a history. So,
right. But and if that comment was actually made 10 years ago, and if the arson investigator actually remembered or thought that
right.
it was something,
Mhm.
right, the big ifs, then you would think that the arson investigator would have recused himself right, even if he says, oh, I can do an independent investigation. You know what? There's a history.
Yeah.
You do not want one bit of taint on your investigation.
And that's a really good point where if you were the investigator and you are now investigating somebody who you have a history with, even if the claim was false, even if the allegation against you is false,
Right.
you should probably step away from that investigation,
Right.
and have somebody else come in and just hands
Because
off.
it's going to be raised against you. It's going to
Yeah,
taint everything. And
yeah,
it did
good
taint
point.
it in the sense of as you said, provides motive.
Yeah.
Right. Okay. Anyway, let's go to Colorado,
Mhm.
where these are just allegations. Nobody should, right? These are not facts like the above. And here we have a probationary firefighter. So start with that, right? Probation. And I presume most states, when you're on probation, you probably don't have a protected job. I can't say all states, but anyway, so she was terminated, and she claims that she was the victim of race and gender discrimination. And it's interesting. So, okay, so we have a African-American female, and she was criticized, and I don't think there's a dispute about this, that she went to a call involving a child, and the parent, and she came across apparently as rude and bothered by having to be there, according to the parents, right? Which is enough. It doesn't matter whether that's true. Parents said it, and right. But she was issued a written reprimand
Mhm.
for that. Even though she says, well, the lieutenant didn't say anything. I don't know that he had to say anything to her.
Well,
Maybe
the
that's not
lieutenant,
his
the
job.
lieutenant actually came to her defense. Okay, the lieutenant said that there was nothing inappropriate, but that doesn't mean there was nothing inappropriate. All that means is the lieutenant, his version of it was that she didn't do anything wrong. Because of course, the lieutenant,
Right.
that might be a little self-serving on the lieutenant's part because he doesn't want to get himself in trouble and his crew in trouble. So bottom line is she includes that part of it, but it's
Right.
possible for the officer that was there to not have considered anything to be inappropriate, and the investigators in the department to have disagreed with that.
Right, right. And look, when somebody acts a certain way, there's the actor, and then there's a person making the perception. So
Right.
maybe the lieutenant didn't perceive it. Maybe it didn't happen when he was standing there, or maybe discipline is not part of the lieutenant's job description, whatever. But in any event, she's issued a written warning. Now, this is what she then starts saying is pretextual. So she said that she complained about this discipline and said it was based on her race and her gender. And I don't know, frankly, is she saying that, and this isn't the main part of it, but is she saying the department is discriminating against me, or the department's believing people who made a false allegation against me? I'm not totally sure. Departments, when they get a complaint from a citizen, you'd normally talk to the citizen, say, what did you see? I presume you'd then talk to her partner, the lieutenant, say, what did you see in here? And then they make a determination. But whatever it is, they made a determination.
Well, let me say
Yeah.
right up front at this point, I think she's off base. I,
Yes.
I I think she's totally off base. Okay, up to this point,
Right.
but she
Now,
has made an allegation of race and gender discrimination. She has made those, and that's critical.
yes.
Go ahead, Brett.
Yes. Right. No, that's totally true. She gets past the first test, right? But now here's what really happened. So now she says, listen, I have a nose ring, and I was told to take it out of me, and she does, but she replaced it later with a clear one, because you're not supposed to have anything that's perceptible or seeable. That's the policy, which is a fair policy, right? You can't have anything. It's just a uniform policy. You can't have any piercings that are easily visible. And so she replaces it with a clear one, because if for anyone who's gotten nose rings or other piercings, when you take them out, they tend to close up or they can become infected. Not me, but certainly my daughters know this. But in any event, she then has the clear one, but she's reprimanded again, despite what she claims. Other people also have clear ones and are not being right now. That is a good claim, whether it's true or not. That is, I'm being treated differently than others, exactly the same. That's the claim. I'm not saying that's true, right?
Yeah,
and if that's true, what's the reason?
And I also want to point out that at this point, that's insubordination. Your officer has told you to take it out, and without checking with that officer, you make an assumption that a clear one is permissible.
Maybe not an assumption if other people are wearing the same one.
Let's take it one at a time. I think when I tell a firefighter you need a haircut, and they cut one hair, and you know what I'm saying, and they're trying to be cute about it. That's insubordination. And when I tell a firefighter I don't want to see a eyebrow ring or a nose ring or a tongue ring or whatever it is at work, you know, it's against our policies, and they come back with a different one, that is at least it's teeing it up for insubordination. Okay. But you just raised the really good point. Is it reasonable for her if she sees males, white males or other people with the clear ring, then I think that changes that from insubordination. But in the absence of that, I would think that's insubordination.
And that's I think that's basically her claim, because she ultimately, what happens is she's terminated for failing to comply with the instructions of her supervisor. Now, if it was me, look, you don't, well, in some states like New York, you don't have to give a reason to a probationary firefighter as long as it's not being, discriminated against. You don't need a reason. Now here, maybe they gave a reason because they want to, protect themselves against a claim of race or gender discrimination. That said, that's going to be the question. Do other males, do other people who are, either white or male or whatever, do they also have the same thing such that they're not disciplined, or do they not? It's a fair question. I think that's what the question is going to come down to in this case.
Well, and I think this would be my prediction. She's going to lose on the race and gender discrimination. And if she wins, it's going to be based on retaliation, because even if her initial claim of discrimination was wrong, she made a claim, and then as a result, she had an adverse action, which is retaliation. Now, the department can go back through the McDonnell-Douglas balancing test. We talk about that all the time. She creates she gets past the first burden shifting. Okay, so the burden initially is on her. She shows, I made a complaint. After I made the complaint, I was terminated. Okay, now the department's got to show, well, you were terminated because of this insubordination. And now burden's back on her. She says, look at all of the white males that were doing the same thing. Now, she can't prove that, she loses.
No question.
But if she can prove that, that
maybe she loses. And I'll tell you the interesting part of this. If they were racist, or anti-female, they had the perfect opportunity at the beginning after the first citizen complaint where they never would have been questioned, A citizen complains whether they were overreacting or not. They could have gotten rid of her right then if they wanted to. If they were truly racist, they had the ability there. So I would be arguing to their defense, if racism was our motive, why didn't we do it a couple of months back? We had it. Now, again, I don't know what the laws are with probationary, in Colorado. If the laws are you need no reason to terminate without cause at will, then I think they have a good defense. But I agree that it's definitely going to come down to who else had those rings, because that's her claim, right?
Well, as I when I lecture on this, I talk about it all the time. Even a caveman attorney can win a retaliation claim, because if she's got to prove race discrimination, she may not be able to prove race discrimination, but she can prove retaliation simply by showing that she complained about something, true or false. She complained about it, and then as a result, something bad happened to her. That's retaliation.
And to our listeners, viewers, we constantly, I think you've said it probably 100 times, when there's a discrimination claim, there's always a retaliation claim that seems to follow. And that's a problem of both reality of the circumstances, listen, we could only take so much, so we fired her, right? Yes, she complained in the interim. She probably did that to protect herself. I don't mean here, I mean generically, right? People who are on the way out typically will make some sort of claim to protect themselves, whether it's discrimination, bias, whatever, right? Or the department really has a real reason to be, going after them. I don't know. Retaliation always rears its ugly head, and sometimes you can avoid it. Sometimes you can't avoid it. But to the employees out there, when you don't put something in writing, you're really casting it in doubt whether you actually really made a claim, right? That you're being retaliated against. So on the employee side, I hope you put something in writing that can be investigated. On the employer side, I hope you investigate. But, retaliation always follows discrimination. Okay, let's go to Rochester, New York. This is disgusting, but as Curt said a million times, not surprising. So look, very simple facts. Unfortunately, we have a former Rochester, New York firefighter sentenced to 17 and a half years in prison. Now, first I was shocked because I thought the claim was he just possessed child porn, which deservingly should get you in prison. But this is a quarter life sentence or half a life sentence in his case. So what got it there was he posed as a teenage boy, causing other minors to produce and send him sexually explicit images of themselves. There you go. There's the reason you and P. Diddy can sit in jail altogether, right? Because you now have caused people to create it. You're not, and I'm not accusing this, just viewing it and collecting it, which is sick enough, but you are actually causing someone to create it for your benefit. Done. He should be in jail. So, and as a note, not surprising to me, he apparently used the internet connection at the firehouse to do this, which why, as a policy, and if you're in our must-have policies, Curt and I gave you one, data transmitted over someone's wireless internet is easily searchable. There should be no expectation of policy. You should have a policy that says that. The FBI is going to get it as soon as you, right? The FBI is getting this stuff regardless. But nonetheless, you as an employer can search the use of everything that goes over the internet. You can see the logs. You can see what's connected to. You can see who's doing it if you want. And you can see.
If you have the policy, though, you got to have the policy, because we've got cases that say that that firefighters have an expectation of privacy. Let me rephrase that. Yep. Firefighters can have a reasonable expectation of privacy in what's on a fire department computer, as well as what transfers in and out of the fire department's internet system. Yep. You need to have a policy that puts them on notice that you claim your right to review it, right to share it, et cetera, et cetera. There's also a federal wiretap law that if you're recording your employees without their consent, you could be in criminal liability, but as well as civil liability to that employee. So bottom line is you gotta have a policy. You absolutely positively have to.
And if you're in our must-have policies, you probably have that already because we've sent that to you early on. Now, that's so important to have those policies. Okay, lastly, let's wrap up. I don't know whether this is silly or not. I'm not trying to demean it. It's a settlement, but we have an Ohio city that has now settled a gender discrimination claim. They settled for $18,000. This is a nuisance value type claim, but we should go through the facts or the allegations. There's no facts or allegations. So he claims in his lawsuit, now settled, that he was forced to resign back in 22. Look, we've got a male. He was hired back in 18. He claims he was subjected to unwelcome sexual comments. He claims that he was perceived, which is enough. You don't have to actually be disabled or gay or whatever. You just have to be perceived to be a protected class. And here he was perceived to be homosexual because he didn't want to watch pornographic imagery. Now, why there's pornographic imagery in the firehouse is if that's true, that's on the chief captains and lieutenants. That shouldn't be happening anyway. Aside from that, in any event, the part that I think why you put this up here is what's really interesting about this. He claimed he was given stereotypical gender-based roles, such as grocery shopping and doing laundry.
What's
I'm
next? Doing the
sorry.
dishes? I mean, come on. Somebody has to do it. And it's
And we
usually the
enjoy doing
junior
the
firefighter. Come on.
right. And I got to tell you, going grocery shopping, A, is usually a group activity,
It
right?
most
Usually
certainly
the
is.
engine or truck goes. But
Mhm.
B, that is so traditional firefighting that to go shopping, to me, that's an honor. That's part, and it's not a you're the probie, you do this. That's part of our good tradition. And doing laundry, everybody does laundry. Now, I don't know
Everybody
if
does
that,
laundry. Everybody does dishes, unless it's assigned to someone, for example, to the probie or whomever
which
it
we've
may
seen a
be.
case on that where they're fighting over it.
Go
I,
figure.
and I got to tell you, so what I really found interesting is that, and the question is the department going to start mandating changes like a cycling circle of who goes shopping and who does laundry so that there's no question? It can't be a sign. I don't know. I'm curious how the department will react to this. If anyone's in the department,
What
I'd love to know. They probably aren't reacting at all to it because it's 18,000 nuisance claim, probably paid out by insurance. Who knows? I don't know.
Brad, I want to
But
talk about this one in a different light, going back to something you and I and Chip have talked about for years, okay? But in this case, we've got someone who, I mean, I hate to say it, but we've got someone who is going to get an attorney who's probably not a firefighter, and the city is going to get an attorney who's not a firefighter, and they're going to argue this case to a judge and probably a jury who are not firefighters. And they might successfully pull the wool over everyone's eyes that it's gender discrimination to make someone do the dishes, to make someone go purchase the food for the group meal, or to do the laundry. Okay, because I think that's what you're going to have to try to do, is to pull the wool over the eyes, because you're going to argue that non-attorneys are going to argue it to a non-attorney. All right. What if we had a court system that was really firefighter oriented? Okay, where you had a firefighter who's look as the judge or the jury who's looking at
right.
something like this, right? So I know that's pie in the sky, and I know it wouldn't be constitutional and all the
No, but
other
it's why we have
excuses
expert
why.
witnesses, right? That's the role of your expert witness to
It,
say,
it,
no,
it
look, in
is.
our environment, that's exactly the tradition without bias. That's
I know, but you think about some of the things that happen in the firehouse, some of the comments, some of the jokes, some of the joking around, the practical jokes and all that.
yeah,
If, I worked for the NFPA for a couple of years, which I consider to be really cubicle world, where everyone works in their own cubicle. There are things that are said and done in firehouses all across the country, probably all over the world, on a daily basis that would get you fired immediately if
yeah,
you work
yes.
in cubicle world. But we have attorneys and judges who are used to dealing with cubicle world. So how do we educate them about sort of the norms?
Right.
And I
I'll give
think
you
if
one of
we
my
could, if
favorite quotes. So one of my favorite things, it was an instructor I had forever ago, and I've copied him. But he said it's exactly your point. And he says, imagine this in court. So, Mr. Pinsky, during the workday, you grabbed the pelvis of Mrs. Smith. Yes, I did. And you squeezed her pelvis. Yes, I did. And then you ran your hands in a squeezing motion down her legs, each of her legs. Yes. And you touched her feet. Yes, I did. And you pushed and you grabbed her feet. Yes. And then you held her hand. Yes. And you touched the back of her neck. Yes. And you touched her forehead. Yes. And you even squeezed her rib cage and touched her abdomen. Yes. And this went on over 5 minutes. Yes. And you did it in a whole bunch of front of other people. Yes. Why would you ever do that?
yeah,
Now, in the cubicle world,
that's the question that never gets asked though.
well, of
But
course, right?
right.
But
But
so then you come back on stand, but it was part of the EMT class. We were teaching how to do a primary and secondary survey. But in context, that's
right.
exactly it. You did
Right.
what?
Well,
Anyway,
at
I
any
agree.
rate, I think there's an opportunity out there for whether it's mediators or an arbitrator, or when you have a firefighter legal problem,
Right.
have a firefighter involved in the decision making, as opposed to somebody who's maybe used to be in the state legislature, was an attorney, probably not a good attorney, and somehow got himself nominated to become a
And the
judge.
plaintiffs will never want that because
I
they
yeah,
want the cubicle view, right? They
yeah,
don't want the the actual reality of the situation.
Yeah.
So
Anyway,
anyway, that's
pie in the
it for
sky.
today.
Pie in the sky. All right, man. Well, that's that'll do it for another edition of Fire Law Roundup. Brad, we'll see you again next week. And thanks, folks.